Well, hello, everyone. Happy Wednesday and welcome to Legacy and Libations. My name is Bill Soroka. Welcome to the show where we talk about life, death, and the beverages that get us through it. I'm here with my incredible co-host, John Braddock. Hey, John.
Hey, Bill, how is everyone tonight? Everyone's looking great out there. Big wave to all.
Look at that. Enthusiastic, good mood today, John.
Right? I'm excited. We'll be on here for 4 or 5 hours now.
Oh, you see those smiles just turned upside down.
You're like,
well, I'm excited to be here as well, guys. We are committed to helping you educate yourself about the importance of building and protecting your own legacy. We're doing that with special guests. The way the show is going to work out, we're going to introduce you, or John's going to introduce you to our special guest attorney, licensed in both Florida and in Georgia today. And then after great conversation and a Q&A, we are going to do a quick workshop style lesson on how to use the My Life and Wishes Legacy Vault. Altogether, today's conversation will take about an hour. We usually cut this off right at that 55-minute to 60-minute mark. John, I'm excited about today. I'm going to turn it over to you so you can introduce our guest.
outstanding. Thank you, Bill. Well, I'm super excited today to introduce Jadina Gustav to you all. Jadina and I have known each other probably about 6 months or so. She's down in the Florida area, although today she's up in Georgia. What can I tell you about Jadina? First, I call her Attorney J, and I know she goes by that. So Attorney J is a devoted wife, mother, daughter, sister, not to mention an international best-selling author. She places God at the center of her life, like so many of us do. Beyond being an accomplished attorney, she's an author, public speaker, and a servant leader within her community. She's born and raised down in Miami, Florida. BA from University of South Florida. Received her JD from the Regent School of Law in Virginia Beach. And interesting, while she was at Regent, she served as chair of the Black Law Students Association, an executive board member and competition team member of the Trial Advocacy Board. And what really touches my heart, she's a mentor and a tutor to incarcerated youth in Norfolk, Virginia back then. To say she's busy is a complete understatement. She's the founding member, managing partner at the Saju Gustav firm, specializing in family law, business law, and estate planning. She's admitted to practice law in both Florida and Georgia, and she has offices in Decatur, Georgia, and I believe it's Fort Lauderdale, Florida. Her firm has received, and she has received so many awards that I can't even do them because otherwise we'll never get to talk tonight when we go through. But she's a highly sought after speaker and presenter and the author of a book called Divorce Like a Boss, the ultimate tactical guide to end toxic marriage and fulfill your purpose. Wish I had had that book about 20 years ago. Anyway, Attorney J, so happy to have you with us.
Good evening. Good evening. Thank you so much, Bill and John, for having me. I'm excited that you're sharing your members, your viewers, the loyal viewers with me tonight so that we can have a conversation about legacy.
Awesome. Awesome. Well, as I always start, and I'm always interested in everyone's passion for what they do. So you're an attorney. You're not a criminal attorney. You're not a corporate attorney, intellectual property attorney, personal injury attorney, all of which I'm sure are fun, but you're big into legacy and estate planning. Why?
So growing up, like you said, I am from South Florida. However, my background, so my parents are Haitian and Bahamian. Coming from the Caribbean, I know that my grandfather, he was the founder of a church and all those things. But not only that, he had businesses as well. So he had a lot of wealth at the time that he was living, and he even left a lot. But I always heard the stories of, and I even, my youngest memory of him, or let's say my last memory, I was still very young, probably 5 or 6. And I remember he came in because he would fly in and then fly right back out to Bahamas. And he flew in and he knocked on the door. We opened the door and he has like 2 bodyguards with him. And he has an envelope. He opens up a briefcase. He opens up the briefcase and there's a bunch of thick envelopes in there. And then it has like my mother's name, my aunt's name, my uncle, and he's stopping by just to drop off some money to his children. So, as I got older, I didn't know what that meant. But when I got into law school, I went into my first class and they started talking about estate planning. And I can't even describe it, but something inside of me was like, where was this all why am I finding out about this now in law school? And it just started as we went throughout that year, it started to replay all of the stories I've been hearing on how, grandfather left this, he left that. I'm like, well, what happened to it now? And no one really can explain. He didn't leave a plan. They kind of just did what they did, and they believed that they lost a lot as well. And then that always stuck with me. And I'm like, oh my gosh, if you all knew about this, it would have been very different. And then in my community at the time, even after I graduated law school, it still wasn't a conversation. When I bring it up to people, it's almost like, oh yeah, I've heard of that. I've heard of that. And I'm like, no, you can't just hear about it. We have to be about it. So my fire just grew from there, and it has not stopped. I have like law days at the church where, depending on their age, they come and they get free wills, free health directives, because it's just that important to me that our communities, we're leaving so much a chance and leaving so much just to the government if no one knows what to do. And then seeing families turn against each other, become enemies at moments where they're supposed to be, encouraging one another, supporting one another. If there's a way to prevent that, then that's what we need to do. So that really is what fuels my fire every day for estate planning.
Oh, that's awesome.
I love that you brought up what families can end up doing with each other. I think that's so important. I think death, like alcohol, can sometimes bring out the best in people. It can also bring out the worst, right? So I think if we all knew what could possibly happen, we would take these massive steps right now. How do you, at what age should we be thinking about this stuff, Jadina?
As soon as possible. Let me tell you guys. So I'm married and I have 4 children. My oldest is 10, my youngest is 3. I already talked to my 10 and my 8-year-old. Well, he's now 9, right? Yeah, he just turned 9. My 10 and my 9-year-old about it, but at their level, right? Making them understand that all that we're doing, when they say they want to be this, one wants to be a producer. He wants to produce movies and be an actor, right? So I talk about that even with them. So there's no age that's too young or too old, right? You can always talk about it because it has to be, the way I see it, it's a lifestyle. So I'm always planning for my legacy, because what I say is it's not just the money you leave, but it is the wisdom, my life, what the ups, the downs. I have to leave that for them as well. And we have to do that, because if you just leave money without all of the legacy part of it, the story, whether it's video, whether it's in writing, it's your proverb or your biggest failure, your biggest success and how you got there, then they won't know what to do with what you leave them, So it's very important that we start the conversation early. And for individuals, when they ask me directly, like, okay, how do I know that I have an estate? What do I have? Once you get to that place where you're now generating any income. So even if it's any job where you have a bank account, you're not just, putting things on top of your table where everyone can see it, right? If all you do, you get paid and you just lay it on your table, then they just know to take that and try to bury you with it. But if you have a bank account, you're generating any type of income, or you're going to come into any income. Even if you get allowances, your trust fund, baby, you should create a plan. You should have something in place for what you have, what's yours.
Very cool. It's interesting. So a few weeks ago, we were talking with another attorney on about, what happens, now your kids turn 18 and you send them off to college somewhere, right? We're still their parents, but they're adults, right? And so
Yes.
now, we got a real problem if we don't have POAs, HIPAA statements, those things done. God forbid something happens to our children. But what we didn't talk about is let's take that a little further. So let's say my son meets his future bride in college, and now they've graduated, they've gotten married, the two of them are together. They either rent or maybe own a home, but they don't have any kids.
Yes.
And they're still, they're not thinking estate planning and stuff. Why does a young married couple need an estate plan, even if they don't have kids? Yeah.
All right, that is an awesome question, and something that we don't think about. We always think about later on in life. But when you first start on your journey together, it's important for 3 reasons. So I'll start off with the most simple reason. The first one is that you just don't know what's going to happen tomorrow. You don't know. COVID really opened our eyes to age. It's just a number. Moments you don't know. So that's number one. Anything can happen tomorrow, whether you're young and married, older and married. I know that there was an individual, unfortunately, when I was younger, I think I was in middle school, and they were so excited. They were across from us, our neighbors across from us, and they were so excited. We remember when we saw all the limos coming, and they got married, and they came back, and when they came back, we saw everyone wearing black, and it was a funeral. I was like, what in the world? What happened? And unfortunately, one of them passed away at the honeymoon. They went skiing. So that, just to kind of give you, it's grim, but just to tell you how you really don't know what will happen. The second thing is, and something that we miss out on, is the importance of planning early. Because if I start planning, right? So remember, with an estate plan, you're thinking about, what assets do I have? With these assets, what am I going to do with it today so that it benefits me today? How can I utilize it for me and still create a plan so there's something left? Whether it's just for either one of us, there are times where your parents are still alive and you have a plan. Like a lot of people, we hear a lot of athletes, a lot of people that say, I want to make sure that my mother and my father are taken care of. I want to buy them a home. I want to do that. So when you do the plan early, you are maximizing taxes. You want to think about taxes. You want to think about that from the beginning. You create an estate plan so that every dollar that you have, you're making sure that you're maximizing that dollar. So less goes to taxes, more stay within my pot. How do we keep it in a pot? We create different types of trust. Okay. So not only are we doing that, but it keeps it always at the forefront of your mind. So when there are new business opportunities, when you're promoted, you're now moving more money to whatever you've planned for. So you're not, you know how they say you plan, either you plan to succeed or you plan to fail, but no planning, then you know you will fail, right? So if I make a plan, now, when dollars come in, just like budgeting, when dollars come in, I get to put it in places. But if I don't even think about estate planning at the time, then I'm waiting last minute, probably have not captured everything, but I can guide it as we grow, as we get pregnant, we have a child. I know, okay, where does this plan come in? I remember talking to the attorney. I remember talking to the individual about the estate plan. Let's find out what happens now that we do have a child. And you're just adding to your plan, but you know you're secure. Another thing is peace of mind. Doesn't matter what happened to me, what goes on, I'm okay. And the other thing, you said that they don't have children yet. The third thing is that though you don't have children yet, the provisions within your estate plan can already provide for children. And what do I mean provide for them? I don't have children yet, but when I have children, this is the way in which I want them to have it. You may forget, you may not come back to it, right? But you already have those provisions there. So at 18, if they don't already have a car, my trust can purchase a car for them within this value, right? At 21, they can have this. If at 25, they want to start a business, they have to have a business plan. You can still detail all of those things now, just in case something were to happen to you.
Yeah,
So
I love it.
Pete-
Go
Yeah,
ahead, John.
Bill.
Sorry. No,
I was going to say, so, and I want to hear Bill's questions that may tie in, because you know me, I want to go to a nightmare. Okay. So let's say there's a young married couple. They haven't
Yeah.
done a estate plan.
Yes.
There's no will.
Yeah.
They own a home. They own a couple cars. They've
Mhm.
got some debt and other things. And then there's his family and her family.
Mhm.
And how does that all get resolved? If, I mean, having the will and those kind of things
Mhm.
that's the fix, right? If it's done ahead of time.
Uh-huh. Okay.
But what's the process otherwise? I mean, it's intestate, right?
Yeah, it's intestate, meaning that there's nothing for the court to use as guidance. Now, with the will, I always say will is not enough because you still end up in court. And why don't we want that? If you have nothing at all, you will end up in probate court. Probate court has a number of reasons why you don't want to be there. But first thing is there's unnecessary expenses. So you're going to have to pay the court fees. You're going to have to pay for an attorney because they just require it unless it's a very little amount. Okay. You are going to have to pay attorneys. You're going to have to pay appraisers. If there's no will and the court doesn't agree, then you have to pay a bond, which you don't get back, just to secure whatever those assets are, to make sure you don't, do something crazy, steal the money, and the beneficiary, the heirs get nothing at all. So those are all the things with the probate. You also, it's public. So everybody knows your business. They know how much you left, how much debt you have, who's getting what. And then not only is it public, but it also delays access to those assets because you really have no access until the court grants it. And the court is not going to grant it until all the paperwork is in place, until everyone has acknowledged it, waived it. So it's a very long, drawn out process. But you mentioned family. Let's talk about family. We've seen this happen so many times. Individuals are still young, they get married, and unfortunately, one of them end up passing away because there was no plan in place, especially if they're still under 26, which, after Obama or during Obama, he allowed for adult children to still be on their parents' insurance and stuff. It gives the parents the idea that they're still empowered, that they still have control over their child that has now made a decision to get married. So they challenge that spouse. They challenge the individual, and it depends on what state you're in. States like California will require that you share it with the parent and the spouse, unfortunately, especially if there's no kid involved. So the parent probably was okay, they probably was fine financially, they don't need it, but because of how they feel about you, they take their portion anyway, where it's probably better if you starting out, now you don't have a second income, you should have everything. But because there was no estate plan in place, the parent has to share 50-50 with your spouse.
So we tell that young married couple, look, here's the deal.
Mm-hmm.
Unless you want me and your mom fighting with, his mom and dad.
Mm-hmm. Exactly.
So
Now, yeah, and another thing too, they may not have children together, but what if one person already had a child and then they got married? Now the spouse is sharing with that child, spouse is sharing with parents. It can become a complete mess. Not only that, though we know, we should all be honest. We're in court, we're filing court documents, but a lot of times they're not honest. And then they turn the whole story around and they say that this person, they forced my child into this marriage. My child would not have gotten married to them. And they have family members come in to testify. And by the time they finish painting that picture, the spouse that's remaining is like, oh my gosh, like, forget it, just take it. And they're devastated. So it gets very bad. It can. There's some that are fine, but it can get very bad. You said worst case scenario. They can lose everything, worst case scenario.
That's and so the workaround from that to avoid that is that a living trust?
You don't have that.
The workaround is a living trust, because with a will, you still have to go to court, right? The only thing about that, which is good, is that you've already said your wishes. So you said what you want. You said who's going to get what and how they're going to get it. The court usually is going to go by that unless someone challenging it can show a reason why. But usually they'll go with that. You still have the court fees, attorney's fees. So it diminishes some of the assets, but at least you said something, and most likely the court will go with what you said. So that's the thing. The top protection would be creating a trust, because with the trust, it stays private. You don't have to go to court. The trustee that you select just start getting things done. So if you said that, if I pass away, I need the taxes to be paid on the home. I don't want my spouse to have to work. I don't want, a lot of different things. You're able to still have the individual receive everything they're supposed to receive, and no issues, nobody can interfere. They may try to challenge it, but by that time, everything is probably already dispersed, the way that you said for it to be dispersed.
Right.
And you have the privacy and no delay.
That's huge. And I think it's so important because so many of us work so hard to build a legacy in the first place. So if we
Yes.
don't have a plan, it sounds like the state makes a plan for us, which is very
It
costly.
does. So every state has intestate laws, and they say the order in which individuals receive property.
So I'm speaking from personal experience here in the procrastination realm on these. I fully recognize, I've recognized for years how important this work is, but or this having an estate plan in place is. I even had a life-threatening medical event happen last year that was going to ignite me and move me forward, and I'm still dragging my feet. So, and I know that I'm in good company, because I know that after conversations, there are people on this call right now that still have not taken the action required. So my question to you is, what's that tipping point? Like, what in your experience pushes people over the edge to finally do something?
Okay, so what I would say is, for the calls that we get every day there's estate planning calls. The ones who are ready to hit the ground running is because they've just experienced something, or they're close enough to someone who's experienced or going through a probate process, or lost a spouse, lost a parent. They're like, oh my gosh, this is a mess. I don't want this. Let's go. Or they've had that experience. Those are the ones where they're just ready to go.
Yeah.
The other people are those that have a need, right? So there are those that's trying to get an insurance plan, and if they have a will in place, they get more benefits, or they get to lower it. So there's benefits of getting it done. Those are the ones that's ready to go too, because it's a benefit right now.
Yeah. What do you say to the ones who don't want to learn the lesson the hard way? What
For
advice?
those who don't want to learn the lesson the hard way, well, you need to pick up the phone and call. Like you have to just, because what happens is we become overwhelmed by our thought and ideas of what it takes to get something done. And by the moment you get overwhelmed by it, you're done. You don't want to deal with it. You just put it in the back burner. But after a conversation with an estate planning attorney, you realize, oh, it's what I was thinking all along. Like it's what I wanted to do. You just kind of gave names to it. You gave a process to it. And it's not as difficult, nor is it as complicated as people believe. And another thing that I like to tell people is because they're, oh, well, I really don't want to pay that money now. I've already told, I only have 2 children. They're both adults. I already told them what I want to happen. So I'm fine. Like, there's no reason to spend that money. Well, my response to that is, it's nice that they know what you want them to do, but they have no power to get it done. They can't just go into the bank and say, hey, you know, my mom's whole life, or yesterday, right before God, you know, God took her home. She told me that she wanted me to have this bank account. And then you go to this place and say, yeah, so I'm supposed to get this retirement account. You can't do that. They have no power to do what you told them to do. So if you want them to have the power to do it, you literally have to do the plan. And if you're thinking about money, the amount of money they're going to have to spend in order to get access is always less. It's always less. I mean, for example, there's a probate case that's ending right now. We spoke to the realtor that was helping them before the father passed away. She told them almost every month while selling homes in 2021, listen, I have an attorney. You guys should do an estate plan. You guys should do an estate plan. You guys should do an estate. She even set up a call, but then the person never came onto the call. We're now over $30,000 into a probate where all it would have been is like, what, $3,000, $5,000. That's a big difference. That's a big difference. So a lot of times we just have to understand the value. The way that you understand the value is having a conversation. So you all that are here on this line, you're able to hear this, right? Because this is real stories. This is real life that's happening. So now you realize, okay, I need to find out what would the cost be for me? Because think about it. Do you have children that are not completely, you know, on the same page? Because there's some kids that are on the same page, you know, this probate will go real fast, like 90, 180 days done. But there are those where it's 2 years in because there's the one that just don't like the other and don't want the other to feel like they have power. It's a mess. It's really a mess. But the value in doing it, that peace of mind alone that I hear from clients is priceless. Peace of mind, you can't put a price on peace of mind.
That is so true. And that's one of the main reasons I love being a part, you know, as a mobile notary, being a part of trust appointments, trust delivery appointments, because the energy at that table is just this relief. They are so, they feel that you feel it being a part of that process. They're just like, all right, we got this in place finally after 40 years, you know.
Yes. And especially for those, I can say that the ones that find it most rewarding are 2 individuals. Those that are later on in life, and they've been thinking about, and then they got it done. And then my second, which I don't know, it's a battle for number 1, are those with special needs children that will become adults and they remain special needs. Those are the ones that have the most relief because they're like, listen, I really didn't know what was going to happen. You know, what would happen next? And they're not aware of the fact that if you have a special needs child that's getting supplemental benefits from the government, if you leave, and this is just a little nugget, but if you leave money outright to them, the government will count it as income and they lose everything. They lose those governmental benefits. So those are the ones who are like, oh my gosh, they can still get, because they thought it was one or the other. They thought it was just, hey, what I leave is all my child would have. But after they find out that, no, it's not just what I have, it's also, I can create it in such a way that they don't lose their government benefits. Those are the ones where, I don't know, it's a battle between those that are a little older, they live a longer life, and special needs. Yes.
Yeah, I can see where that would be absolutely rewarding.
Speaking as a parent of a 30-year-old special needs child, I've had a special needs trust established right about the time he got out of high school. And he's
awesome.
high functioning, but it's one of those things that you do as a parent. It's like, what happens if I'm gone? Who's going to take care of the child? How are they going to be taken care of? They can't have more than $2,000 in their bank account at the beginning of every month, you know? And so anyway, God bless you.
I didn't know that. Awesome.
Yeah. So it looks like we got a few questions. Bill,
We do. Yeah. Yeah, I'll jump in there. I was going to ask Gina, because obviously I'm going to put your information in here. We know you're licensed in Florida and Georgia with some room for movement as well. So if you're in these states and you'd like to reach out to Gina, she's made herself available via her website. There's a consultation call. There's social media you can follow on, get to know her and like her a little bit too. The other thing is, my question for you, Jadina, is for people in other states, like how do they choose the right estate planning attorney?
Great question.
That is an awesome question. That's an awesome question because I've been having conversations with a lot of attorneys. I don't know if you guys saw my social media, but every weekday I do quick questions and different things. So I've connected now with a lot more attorneys, and I'm trying to create a network because I want people to get attorneys who really see it where it's a whole lifestyle, not just a document prepared because you asked me to prepare it. And some of the things you should look for is their stance on just planning, like the planning documents versus legacy planning. There is a difference. And some firms they make you pay separately, right? You're paying for estate documents. And if you want to add legacy, then, you'll pay an extra something. I'm not knocking that at all, which is fine. But for me, I can't see an estate plan if it doesn't include legacy. So that's already built into the idea of, I cannot guide you in preparing yourselves and getting all your assets together, making your designations, making sure that is customized to you. And there's no message from you as to what to do next, how to use it, how to move forward. So that's something that's important. And if that's important to you, then you want to make sure that that attorney sees that as an important part as well. You want an attorney who can educate you, because I find that clients are more receptive and it is more effective, meaning they actually fund their trust. They move forward in informing, like they follow when they know why they're doing it and the importance of each of the steps. So you want to make sure that that person can explain the process to you and not just give you a document, because you may end up losing out on the benefit that you think you have. What do I mean by that? If you create a trust, just creating the actual document does not bring it to life, is the only way I could say it. It isn't enforceable immediately until you actually transfer funds into it. But you need to know that, right? You need to have that conversation without it just being on a paper, because you could miss it. So I would say, an attorney that's going to educate you, going to really make sure that the key things, that the key things, and that's available even after. So that's something that was important. And it was my conversation with John over a few months ago about how important it was. And he helped me outline what our client care package would be, because we would reach out and we would say it, but having something there that you can actually look at and understand what you have afterwards was very important. So I would look at those three things.
Yeah, excellent. Thank you so much for that. I appreciate that. Let's jump into the questions.
Yeah.
Shall we? All right. And so, Jadina, if you run across anything that you can't answer or want to refer out or follow up later, I'll be happy to match people up here.
Okay.
So J-Matt says, what happens if wife passed away and we had a house? Can I sell the house without going to probate, or do I need a trust? In Texas, both partners' name are on the house deed. How the courts decide, it looks like there might be two questions here, and then how does
so let me take the first one.
Sure.
First thing, if both of your names are on there, unless there's something different, meaning the language does not say right of survivorship, or it's not treated as a marital trust, a joint tenancy with marriage, then you automatically have it. You don't have to go to court. You now own it. You would just file with your county, so your county recorder's office, the death certificate. Once they know of that, then you have full ownership. You wouldn't have to do anything else. Probate is not necessary for that. That means you own it.
Excellent. And then the follow-up question was how the courts decide a probate fee or percentage or amount. Do you have Around that?
Well, generally and I've seen it across the different states. There's two things. There's two things that they have. So there are very simple probate estates, meaning it's below a number, and every state have their number. It's below a number, then the attorney is kind of capped a little bit at a percentage of the value. However, once it goes above that, it's really going to depend on what that attorney hours are and how detailed they are in providing it, because the heirs, as an heir, they do have the power to challenge. Like there was one where I came in way later, years after, on a probate, and the attorney, after I believe it was 5 or 6 months, charged like $60-something thousand. And the heirs challenged it and they were able to get it reduced. I mean, it was still in the 30s, but they were able to get it reduced. So you have some power over that, but the court is going to go based on what that attorney submits, because you have to have an affidavit as an attorney. You have to put those hours. So, who was working it, what was the rate and all that. So they want to trust what we submit to them. So they're going to take whatever it is that the attorney says.
Wow. Juliana says, how about if the settler has assets or property out of the country? Should this out of the country property be also included in the living trust?
Yes. Okay. So I deal with that all the time. You do want to have it listed there, because remember, your estate plan is not, it's not a probate, right? There's not a judge that's going to come in and say that this, you're going to do this with this, you're going to do that with that. Your estate plan's primary goal is to inform the individual that you're leaving as the trustee, so the successor trustee after you, if you're the first trustee, instructions. So letting them know what country it is, or states, right? Whether it's different states, just let them know what it is and be as descriptive as possible, because that person now will have to connect with professionals in that country in order to capture those assets that you have in another country. So you definitely want to have it listed, because other than that, you'll probably just lose it. And the state will take over. Anybody will just kind of squat and take it. So the being detailed as possible is what you want to do in your estate plan for everything you own or could possibly own. You can even put, I remember I took care of someone, he was in his 80s and he said he will leave me in his will. You put that person's information, their name, all of that, and your trustee needs to check that out and see if there was something left for you. So be as detailed as possible.
Great advice. And what advice would you have to somebody who created the trust 26 years ago, but hasn't done much with it since?
Well, you definitely have to review that. Review it, make sure the people that you were leaving things to are still alive. Make sure that you still want to leave it that way. Make sure your trustees are still capable of stepping in. Maybe you had a falling out with your best friend and that was going to be your trustee. Make sure that you update that, remove that person, because if not, the trust really won't be as effective if they cannot find that trustee, and you'll end up in a probate situation.
All right. And Valerie, going back to your example about a California couple where one of the spouses died and has to share the property with a mother-in-law or something. Valerie says, if California is a community property state, why would the parents receive anything?
Okay.
Spouse. Okay.
So remember, and this goes kind of into family law, the family law side of things. So when you get married, you have marital property and you have separate property. Marital property is going to be covered under community property. What do I mean by that? So everything that you acquired while married, that was not an inheritance from a parent or a gift. So if I cannot identify it as a gift or an inheritance, then that will be marital property and it'll be split 50-50. Not the same for separate property. If I have separate property, which are things that I entered into the marriage with that my spouse did not add value to, things that are a gift, things that are inheritance, those things remain my own. And because it remains my own, it can be split according to the law, the intestate law of the state.
Wow. Okay, great. Thank you so much. And then I think you touched on this a little bit, but Crystal has a question. What if I don't have children, but my husband has 3 kids and 5 grandkids, and I don't want everything to go to his kids?
All right. I am so happy because I have done videos on this. All right. So what we want to do is be very specific. I say that there is a tool that we do not use because there's a stigma attached to it. It is a premarital or postmarital agreement. What that does is what you can do for estate planning purposes and protecting the value for you, you're able to identify in that premarital agreement or postmarital if you're already married, and you're putting in there, the person has a right to this, the person have a right to that, the person has a right to this. Now, let's say that, because you said you don't want the person to get everything, because usually when you're coming into a marriage and you already have assets, you've already decided what you probably want to leave for your children, right? So your spouse probably have a home before or a condo before, then now you guys have a home. He may have wanted that condo to stay for the children. So in that agreement, what you're doing, you're saying, you know what, I know the condo is for the children. And your spouse is saying only the condo is for the children. However, everything else that my spouse have a right to is for her. And then in your, because that's just one of the tools, right? That's within the plan. And within the estate plan, we're specifically saying, I have this child, I have that child. They are limited to this. My spouse gets everything else. And that's the power of an estate plan. Because if you don't have one, you are going to split what your spouse have with those other children. And the rate varies based on the state that you're in.
Amazing. All right. So a couple more questions if you still have a little bit of time, Jadina.
I do.
All right. Thank you so much.
Not a
Sheila
problem.
says, should you update addresses and contact info if you've moved or changed phone numbers? Does it need to be redone, or is there an easy way to add a contact sheet or something?
Yeah, no. You don't have to. So usually, and it'll be very rare if there's an attorney that created an estate plan for you that don't provide a portfolio. So the portfolios that we prepare, it has extra folders, it has extra clear tabs. And something like that is not really necessary for signing, but it should be added into your portfolio. So you're in control of that. So you can go ahead, even if you handwrite it in, you rip that paper out because it's not an official part of the trust document. Your contact sheet for professionals and all those things, you should definitely have that as a part, but just make sure to put it with the portfolio so that your trustees, heirs, everyone can actually find it.
All right, great question. And then finally, Raymond asked an interesting question. He says, how do I sell trust? Can I get a lawyer on retainer and sell their trust? Or do I need a Series 7 license or what? Do you have any perspective on that, Jadina?
And he said, sell a trust. I'm not sure what he means by sell the trust.
I think he wants to be an advocate, working in conjunction with an attorney, sharing the opportunity with his network and probably receiving a commission for it. Have you heard of such a thing?
Okay, well, receiving a commit. Now, I've spoken to different people because they're like, they see the value in it, right? What you can do individually, separate, because every state in this great United States of America have that attorneys cannot split fees with non-attorneys. However, an attorney can receive referrals, can receive, I can be an affiliate attorney for your membership, for whatever your organization is, for Notary Coach, for My Life and Wishes. I can be your designated attorney that you refer your clients to, or you can say I'm an affiliate, and then you get it in there. Now, you just have to create some type of value for those individuals, and then they pay you directly before you send them off to us. But we cannot actually split any fees or even pay referral fees out as attorneys to non-attorneys.
Perfect. Thank you so much for that. I like your thinking down there, Raymond.
No, that is awesome. I love it. I love it. Like, we can have a conversation. There's ways to receive some value, since you see value in it. I know there's value in it, but there's ways without breaking the professional rules.
Yeah, exactly. I think we see so many cool opportunities of mutual prospecting is what we're calling
Yes.
it, where an attorney and a notary basically partner up and
Yeah.
prospect together and change lives and bring peace of mind. It's a great win-win.
It's
I
a
love
good
that.
one.
Yeah. John, any follow-up questions or last minute questions?
Boy,
I
I
like
don't
that.
think so.
Bernice said a success fee.
I love
I
that.
like it.
Yeah.
I think I'm gonna steal it, Bernice.
Yeah. Bernice has got it, that's for sure.
got it.
No, I would say, again, Bill has posted your contact information. I'd encourage people, if you have additional questions, I mean, whether you're in Florida or Georgia or not, you might be out here in Arizona, you have a question, you want to reach out to Jadina, she'll, be happy to provide you with any information that she can. And yeah, this has just been great, Jadina. We're just so thrilled that you were able to join us tonight. Does anyone have any additional questions or live questions they want to jump on the screen and ask Jadina? And throw a hand up.
Oh, there we go.
Crystal, thank you.
Martha.
Hi, yes, I'm from New York. Question about once you fund a trust, you said earlier that you have different trusts. Are you talking about trust for real estate, trust for your car, trust for your bank account? Is that what you meant when you said?
Oh, no, I meant different types of trust. So there's insurance trust, there's Medicaid asset protection trust, there are marital trusts where you pass the money on, basically a limited amount of money without any taxes to the next level of beneficiaries, though your spouse gets a benefit from all of that. So I'm talking about the types of trust that fits what you're trying to get done. But all of those things that you list can be in one trust, all of the things you listed.
Okay, so in this one type of trust,
Yes.
can the beneficiaries also be the trustee?
Yes, the beneficiary can be a trustee as well. You just want to make sure that unless it's the one beneficiary, you want to make sure that it will not cause trouble. If you have multiple beneficiaries, I would have them as co-trustees, only because you don't want a challenge to your trust. Or if you can just name someone else, if it will cause problem. If it won't, then you're fine. But if it may cause issues, then we would try to find a workaround to not invalidate the trust.
So in order to avoid piercing the privacy of a trust,
Yes.
One has to have multiple or a backup trustee. Is that what you're saying?
So you want to list a trustee that will not have personal interest in the actual trust assets, unless it's just them or them and their children or someone else, because it may not, but it can lead to the other beneficiaries feeling as if, well, I don't want you to control what I get, and they may not trust. Now, there are measures in place in every trust where you can ask for an accounting. You can look and see what's in there to make sure it's being done well. So, I mean, there are safeguards in place, but I just usually, when I'm in conversation with individuals and clients, and they talk about just putting that one child, I always say, what are the dynamics? And you want to think about all those things as you make that decision.
Do you offer this service where you behave as the trustee for people who don't have a third party, a neutral third party, you know what I mean? Like,
yeah, I know what you mean. So we've partnered with professional trust administrators to get that done. So we would be able to get you connected with a professional trust administrator. That's what they're called.
Okay, thank you.
You're welcome.
Great question. We've got one more in the chat before we let you go, Jadina, and it's J Matt again, and he has 2 kids with special needs, and he's wondering if he needs 2 separate trusts for their care.
Okay, so for the special needs trust, you will not need 2 separate trusts. So the trust that lists the individuals in there and the assets that they're going to receive, the importance is that language. So the language that we have in there is very specific for state and federal compliance to make sure that we do not interfere with the government, the supplement of benefits from the government. So once we have the language in there, we have the beneficiaries listed, then it would apply to both. Because what we usually do, we don't usually have multiple, but usually there's one that has special needs and there's others that don't. We don't put them together because we don't want that other individual to be restricted, right? Because there's restriction. So if you have two, then we would put them in there and they would both be covered by the same restrictions.
And then Jadina, when that time came,
Yes,
that trust was to be funded
yes.
and an account was established, would there need to be two separate accounts if things were split equally, or would just the trustee put it in one account
No.
and monitor?
Yeah, because it's just that one trust. It's just that one trust. And remember, they have no income, so they don't really need a separate account that goes towards them. It's just the way that you provide for their needs. That's the most important part, right? Because the language is basically saying that this is not their income. However, it can be used to supplement any needs when one come up. So if it's housing, you're able to pay for housing, but you're not going to give them the money to pay the housing.
Yeah,
That's
awesome.
excellent. And there was what Yasmin just joined us, and she has one more quick question. I'm curious what your perspective is on this, Jadina,
Yes.
on do-it-yourself paperwork. Like, the question is it required to have a lawyer to create a trust or a will? And
Okay.
if not, what's your perspective on the DIY side?
Okay, so the quick question is no, you do not have to have an attorney to do a trust or a will. My perspective on that is, I have to laugh. And I'm not laughing because I don't want you to do it. It's just because I have a lot, but I'm trying to measure what I'm going to say that makes sense, right? Okay, so the first thing is, you can do it, but the only reason why I don't advise it is not just financial gain, is not the reason why, because one trust is not life-changing, right? But what happens is you're not being advised, and you may get a trust from online and you go ahead and sign that, have witnesses sign, have a notary sign, and it's effective, but it does not cover you, especially for things that we're saying, like tax benefits. If you're over, someone had in there, I think you missed one of the questions. I saw something about being 65 or a spouse is about to be 65 and the person's 51, something like that. If that person go and create a trust and they're listing all of their assets and they're just building up money in there, they're getting Social Security, they're getting benefits, and they're building it up in there, you actually can lose your government benefits because you were not advised in creating that trust. And you created a regular trust when you actually need a Medicaid asset protection trust, So it may not cover what you're trying to get done, and it can put you at a worse off position if you do DIY without advice. And it's kind of the you get what you pay for type of thing. It usually isn't good, right? I didn't pay anything for it. I downloaded it, and it gives me more issues than if I use someone else. So I don't advise it, even if you have a conversation first, but just have a conversation because I don't want you to be in a worse off position by doing DIY.
Great response. Thank you so much for sharing your perspective on that. This has been a great conversation already. Lots of comments in the chat about what they've learned. So thank you so much. John, I'll let you close it out and take us into the next phase of our call.
Okay, well, and this is great because we want to let our attorneys and our guests talk as long as possible and answer questions. We want to do that. Relative to our platform, and that you are all working on and have an accountability partner and you're getting through the process, I just want to touch on one or two things very quickly tonight, kind of like your homework assignment for the upcoming week. So again, log into your account. If it indicates you're still on a free trial, you still can upgrade and save $30 on your subscription with the code For My Family. Okay, so we won't go into that now. We have gone through the important things a family is going to need to know such as who your advisors are. We've talked about the documents and uploaded our trust documents into the vault so family can have that, some proof of ownership documents. We're building the roadmap. And in financial, like we talked about, bank accounts. And again, bank accounts is anywhere we're hiding money, folks, right? So build the roadmap for the family, the banks, the type of accounts, where you're hiding that poker money in the bedroom closet that no one else knows about, because, you know, Michelle would just take all my clothes and take them to Goodwill, and somebody will be really lucky when they buy that brown jacket. The two areas I'd like you to think about for this coming week, which again are pretty easy. One is loans. Any debt obligations you have that your family are going to have to take care of, such as maybe you have a car loan at First National Bank or your mortgage. When we add these, you know, it's always helpful if we have a copy of the document or can scan the front page of the document. But even if we don't, we want to build a roadmap. So what kind of a loan do you have? Is it a mortgage, home equity, student loan, or other? We always have the other option, and we can list what kind of a loan it is. And then all we need to do is put the loan holder. Who do we owe the money to? Let's put the information in and save those things so that family can do it. And again, this is something we can do. You know, we don't have to, you know, overthink this. I can be watching, you know, the reruns of Yellowstone on TV and sit there, and I know what debt I have. I know the loans I have, you know, a car loan, a mortgage, et cetera. So put them in, build the family, because family's not going to know those things. The other thing is credit cards. I can't emphasize how important this is, especially since most of us may pay these days with this thing, our cell phone, right? We might not carry a wallet full of credit cards. But a lot of attorneys will tell you when someone dies, cancel the credit cards immediately. Why is that? That's because of everything that we have on auto pay and recurring pay, right? Our Hulu, our Netflix, our YouTube TV, Amazon Prime, and that. And unless we can cancel those credit cards or turn them off or find the information, they're going to get dinged. So again, build the roadmap. If you have details, put as much as possible, but at least let family know what credit cards you have. Visa, MasterCard, Discover, American Express, maybe it's other, might be your Shell gas card, who knows? The issuing bank and the name on the card is a minimum that's needed. It's all that's required, but it guides family to find those cards, which beats the heck out of them going on the morbid scavenger hunt, which I may have mentioned in the past, but the morbid scavenger hunt is when my children are digging through their dead father's wallet, desk drawer, those kind of things, searching for this stuff. So build the roadmap out and put that information in there so that they can call those credit card companies, cancel those cards, and the $39 for the Wall Street Journal doesn't come out next month and get charged on that card, because then you create all kinds of other problems trying to cancel those things and get them back. So as we go through, to start building the roadmaps, put the banking information in if you haven't, add the loans, credit cards. Investments would also be key. You can figure out real easily how to get that done. What's the investment? It's your IRA. Where's it located? Pretty simple. But if family doesn't know that right away, it's going to be very hard for them to track these things down. Much like the 752 paper shares of IBM stock that we found after my father-in-law passed away in a safe deposit box on the other side of the city that no one knew he had. And it took us 2-3 weeks to actually track it down. So build the roadmap. It makes it easy. Keep working on your platform. It's going to give you peace of mind. It's going to make things easier for your family. For next week, I would love it if when we start at the very beginning, if people could pop into the chat questions that they might have about specific sections of the platform, so that we can address your in particular questions as we get to the back end of the show. Bill?
Yes. That was awesome.
See that? I got us to 5 o'clock. I told you we're going to be on 4 or 5 hours because of the energy in the room, but we get
It
it
was
done in an
perfect.
hour.
Your timing is perfect. Well, I'm going to go ahead and close this out here, and I'll thank Jadina here in just a minute. But also remember, guys, one of the main reasons that we're leading this show, we're having this show, we're talking about topics that are sometimes uncomfortable to talk about. And we've tied this into the training with the My Life and Wishes Legacy platform, is because we want you to take action. This is a safe place to take action, so you don't have to be another statistic of somebody else who didn't have a plan in place. So we're not sharing stories about your family, about how it became a nightmare after you passed away and your family didn't unfold the way that you expected it to. This is your time to do that. We can take this action together. I'm over here on my side taking action in my life and wishes too. I'm making that plan today, and I'm loving and learning in these conversations. Jadina, thank you so much for giving us so much of your time, your energy, your passion, and your information about what you do.
Thank you. It was a pleasure. Thank you so much. And I'll come back whenever you guys need me.
Awesome.
We would love it. All right. So we are going to be on. We've got another great attorney for you next week. The very last week of April, we have a mortician joining us and a funeral director. So if you have questions, ask a mortician. This is your time to do so. And I know already there's some really great questions and weird questions that are coming through already. I'm excited for that conversation because that's stuff we don't think about and you usually don't want to think about, but we need to be thinking about. And that's what this conversation is all about: life, death, and the beverages that get us through it. Thank you so much. We'll see you next week. Bye-bye.